All right.
Okay, so welcome to the 12 p.m. Stream 3 session. This is Cross-National Perspective on Crime and Crime Prevention. This is the first of two of these panels. And we have an interesting lineup the next 2 hours. My name is Jim McCafferty. I am an associate professor of criminal justice at Kennesaw State University. You're not going to hear too much from me this hour. You're going to hear from the panelists in a moment. I'll just direct your attention for the attendees to the bottom of the screen. There is a button that says Q&A. If you have any questions, please go ahead and ask those questions. We'll hold them till after our panelists have presented. And it looks like we're definitely going to have time for Q&A if anybody has any questions that they would like to ask. So I'm just going to throw it to Sandra now and give her the floor.
Thank you, sir. So I'm going to begin my presentation now. So good morning, everyone. I'm Sandra from OP Jindal Global University, India. And I will be presenting the paper that was written by me and co-authored by Professor Vipin Vijay Nair, who is also working as a faculty member in Jindal. So our paper is basically titled Understanding Moral and Social Deterrence of Crime Prevention. And it's premised on revisiting Cesare Beccaria's theories and its present-day applications primarily in USA and India. So our paper basically begins by discussing on what is exactly a criminal justice system. And we believe that it is a system that is used so that the people who have committed crimes and those who have been harmed by crimes can have a reform or a mitigation field. So in earlier times, this criminal justice system was surrounding the idea of corporal punishments like flogging and mutilation. But today, the system has changed. And right now, we can see that the law enforcement agency, the courts, and the correctional system together try to ensure that even those who commit crime get access to a fair adjudicatory process. So scholars have basically taken two approaches towards punishment. One is the legal side, where if you do something wrong, you get a legal sanction. But we are more focused on the philosophical side of it, where the morality of the entire punishment procedure is justified when the punishment imposed is an effective tool for preventing future crime, or in other words, reducing recommission of crimes or recidivism. So on this premise, the philosopher that we focused on, that is Cesare Beccaria, has built a theory of deterrence that is grounded on the individual's perception of severity of punishment, certainty of punishment, and celerity of punishment, and how these perceptions do or do not translate into criminal behavior. And this theory was heavily based on the idea that individuals are rational beings and every person will think about the gains and losses of the actions that they do. So upon our research, we found that in modern day penology, the criminal justice systems are not applying this theory coherently. So for example, we know China. China has the most number of death penalties in the world, with most of it being unrecorded. But the crime rate in the country has not substantially reduced. On the other hand, we have countries like India and USA with high levels of incarceration rates and execution. But there has been no substantial reduction of crime rates. In the other hand, there has been increase of recidivism rates in these countries. So we see that the country is trying to have a balance between the three things of certainty, celerity, and severity, but no country actually follows a model in which all three are applied coherently. And this is what our paper focuses on. So on the theoretical framework of our paper, we basically went back to the classical criminological studies and traced way back to Hobbesian theories, where Thomas Hobbes brought in his social contract theory. Now, in this era, punishment was basically used when somebody dilutes the social contract theory or negates this contract. Following him, we have Beccaria, who came up with the deterrence theory and talked about how swiftness and certainty of punishment is way better than severity of punishment. He, along with his predecessor, Jeremy Bentham, together believed that punishment should only be used to stop future crime or deter future crime and not for anything more. So we see that the early classical philosophers attempted to build a very ethical rationale for inflicting harm on individuals who violate the law by contending that the foundational purpose of punishment itself is to deter future crime in the interest of public. Now, the methodology that we use for the paper is mostly qualitative in nature. We also have narratives of legal professionals in India, and we did a thematic analysis of the same. So, our first point of case study was the United States of America. Now, in the United States of America, when we did our research, we found out that this country has staggering amounts of incarceration rates, like the most around the world. Regardless of this, it was found that the under trial number was very high. So prisoners were basically kept behind bars for years, institutionalizing them, not allowing them a chance to develop conventional behavior. We could also see that the recidivism rate is really high. So one of the data samples we did revealed that 44% of the prisoners released in 2005 were rearrested within 1 month following their release. Now, this country also has a trend and a high level of execution rates. But our analytical study showed that the southern part of the country, which has 80% of the execution rates of the entire country, has less homicide rates when compared to states which have abandoned capital punishment. So essentially, our findings reveal that the empirical data could not justify the deterrent effects of the legislations that US had in place. Despite them having a tough on crime agenda, it didn't really cause a deterrent effect, neither did it curb crime. A second country which we took was India, from where I am from. So the country follows a very archaic system. But the problem in this country is that neither the legislative body nor the judiciary has codified any sentencing guidelines. So it is the judge's discretion on sentencing the offenders as per their whims and fancies, as long as they stuck to the statutory limits. Now, in the recent past, India has shown a shift in their trend, and they have kind of focused more on individualized treatments and rehabilitation of prisoners. But when we did an analytical study, it revealed that the country still has high level of incarceration rates for various offenses, including homicides, sexual offenses, and there were immense number of under trials, and prisons are overcrowded, institutionalization of prisoners. So the system isn't really functioning efficiently. Now, if you look at the recidivism rate or the rate of recommission of offenses, you can see that statistically, yes, there has been a fall from 6.4% to 5% in 2016 to 18. But then I did a little more deeper study and figured out that the Indian system has in fact changed the way in which they were recording these crimes. So now, for a person, only a single crime is recorded, regardless of whether he commits multiple crimes. So the actual level of recidivism is actually getting hidden behind this new method of recording crime. So we can still conclusively say that the system is not very efficient. So after conducting our analytical studies, we have basically come to the conclusion that the modern day punishment system adopts an incomplete application of the deterrence schema, which is actually leading to unsatisfactory results. So our case study example of the United States of America, where there's a highly retributive system of punishment, staggering rates of incarceration and death penalties. But the statistical reports still reveal that this is not deterring crime. The implementation of the system is certain and it's severe, but there is no swiftness in its application. So the individuals are institutionalized behind bars and causing them psychological impacts, not allowing them to develop a conventional behavior or return back into the society. India also, though the punishment system is kind of changing its trend towards looking into more of rehabilitation, it's not really efficient or it's not implemented, is what I would like to say. Because the analysis or the statistical data still shows immense prison overcrowding, immense number of under trials, and a fair amount of recidivism with no substantial reduction in crime. Now, we also did have narratives, and we, in semi-structured questions we had to ask with the criminal justice lawyers of the country mostly. And we asked them and posed questions regarding the role of social and moral deterrence in today's crime prevention strategies. Now, 90% of the responses we received from them was positive in the sense that they believed that both social and moral deterrence is a way in which you can impact the psychology or the inhibitions of a person and prevent potential crime and potential criminal behavior. So they agree to the effectiveness of the deterrence schema. They also agree that the social pressure constitutes a major part in awarding sentences in major high profile cases. For example, in the Nirbhaya case, which I don't know if you guys have heard about, is a rape case that happened in New Delhi, India in 2012. After years of fighting for justice, the offenders were finally executed. So, this case was surrounding a lot of social pressure, and it is believed to have created deterrent effects across the country. So, yes, it is creating deterrent effects, the system we have in place today. But the n number of backlog of cases actually acts as a counter towards this moral deterrence. The narrators also conclusively agree that the efficiency of simply severe forms of punishments like capital punishments alone is not really a deterrent tool or an effective deterrent tool, I would say. So, our research basically concluded in the sense that the need of the hour or the need of every criminal justice system across the world today is to coherently apply the three principles of Beccaria with utmost importance to create social and moral deterrence within criminal justice system, because this is an effective tool and it has been proved by the classical philosophers as a tool to deter criminal behavior, to prevent future crime, and to allow prisoners to come back into the society in a conventional behavior and not recommit their crimes. So, our paper concluded by saying that the modern criminal justice system ought to take progressive steps towards this cause and revisit the classical theories of deterrence to develop an effective crime control mechanism today, as suggested by Cesare Beccaria and a number of other classical criminological philosophers, on the severity of punishment, the celerity of punishment, the swiftness and certainty of the punishment, because this is what we need for a more effective criminal justice system. And that is what our paper was trying to put forth. And I'm open to any other questions and queries regarding this. Thank you.
Thank you, Sandra. I appreciate your presentation. Very well done. If you would stop sharing your screen, and we are going to give the floor now to Jéssica. And then following Jéssica, we have a third presentation as well. If any of the attendees have any questions, there's a Q&A button at the bottom where you can ask your questions. But Jéssica, are you ready to go? Okay, then I'm going to give the floor to you.
I just have to put the full screen on. Wait a minute. Can I go?
Yes, you may.
Okay, so I'm Jéssica. I'm from Brazil, and right now I am finishing my dissertation in the criminal science master's in PUC-RS, and I'm also a Bachelor of Laws. But today I'm representing the Contemporary Criminologies study group from Porto Alegre, Brazil. My research today is named Take Them Down, Reclaiming History through Monument Displacement. And I'm presenting actually research about a very recent upbringing of historical revaluation. And it's very incipient, but I believe it's an interesting way to think about this kind of occurrence within the criminological perspectives. So for this research, I'm actually using bibliographical fonts from various study fields and published journal articles or news. It's been a challenge actually because academically there are few works that deal with this subject still, but my place here is mainly to spark the movement for us to study this. So the object of this research is mainly statues, but I am also trying to focus on historical monuments, plates, and other representations of people or facts through our history. And my aim is mainly to understand and perhaps explain the act of displace, remove, or modify these kind of monuments, and the connection of these acts to a movement to reclaim history. So I'm basically working with a few key concepts, such as genocide, progress, and colonization, because I am investigating history itself. And to this extent, just to make a parenthesis, my main point is that progress, the progress of civilizations, is paved on genocide, blood and genocide. So it's not exactly in the same mode that we know from World War II, but in a conqueror-like mode, close parentheses. I must also pay attention to the concepts of violence and culture, among others. So what is actually a monument? A researcher called Erin Thompson said that a monument or a statue is a bid for immortality. It's a way of solidifying an idea and making it present to other people. So monuments are like landmarkers and a way to remember and tell people that something important has happened or was done by someone. So what does it mean to displace or remove or even destroy a monument? Thompson says that when a monument is attacked, it is actually the point of view that it represents that has been criticized in a physical way. From what I've been studying, so there seems to be a movement of people that are actually rethinking history and how or why these people or occurrences are deemed important. So what happens when a monument is displaced actually? Not much things. In an art preservation perspective, it might be repaired or sent to a museum, but to keep a monument like this is often very expensive. But when we look at history, not much happens in a perspective to, for example, change history books. So who are the people that are represented or to whom these monuments are dedicated? Basically, the people who are represented by these monuments are deemed as heroes. They are important people who have done important / good things for their countries and brought richness to it and to their people. But my question is, at what cost do they do it? Some examples are Leopold II from Belgium, represented in this image, who was recently thrown in a river, as many of you may know. And also the bandeirantes from Brazil, that were explorers mainly, who actually sought and stole gold and killed indigenous people in the name of expansion. So there seems to be a movement of perception and reevaluation of historical movements that lead people to demand change in how it is pictured or told. However, this is not an interesting decision for most governments, artists and conservatives. We must notice then that even now our heroes might be crooked. When Mozambique got rid of the Portuguese detention in 1975, they tore down all of the Portuguese monuments, but their new heroes, they didn't live up to the expectations of the new nation. They were just as bad. They were dictators too. So which side of history is being told? Actually, it's both, but not in the mainstream. The winner's story is the most publicized one, is the one that we often learn in school, but we also get to know the loser's side, and it's a funny word to use nowadays, but we learn it in a different perspective, in a different narrative. It's more of a nationalist narrative of how they survived tough times and how they have to rebuild a nation and rebuild their own people. So people seem to be reconnecting to their ancestors by looking to a different side of history and telling it in a decolonial perspective. And this is done through art mainly, dancing, painting, and reproducing cultural heritage, and in an academical way too. So why is this important to criminology? Why do we have to mind this? Mainly because we have to know history, to not repeat it and to not fall in the problems of a one-sided account of history. If, as I have told you, progress is paved on genocide and violence, we must then investigate who was a victim of it and what was done to them. I believe there are three main perspectives that might be interesting to investigate these kinds of events, and they are the Southern criminology, international criminology, and global criminology. Due to this being focused on a decolonial perspective and in dislocation of the Eurocentric white male view. So this is it for me today. These are my references, and thanks for your attention.
Jéssica, thank you so much. That was very interesting. If you would unshare your screen, we have up last, we have a presentation from two researchers in the Republic of Indonesia. If they would like to, I'm not sure who is going to be leading that. Okay, all right. I will stop talking and let the two researchers present.
Okay, thank you. So, hi everyone. Can you hear my voice clearly?
Yes, we can.
Okay, thank you. So, my name is Fitra, and I'm here with my friend Dannissa.
Hi.
Today we are going to share with you our work about examining the parole programs in Indonesia through the lens of Risk-Need-Responsivity framework. We are probation and parole officers from the Republic of Indonesia. Next. Okay, so why is the discussion about R&R implementation in parole programs is important for us in Indonesia? So let me start about with the R&R framework. The R&R framework itself has gained so much empirical support for its effectiveness in the correctional area in the context of correctional treatment. R&R also forms the basis of many assessment instruments and rehabilitative treatments for criminal offenders, such as youth level of service, and let's not forget about the level of service inventory by Andrews and Bonta. Next. But despite its well-known popularity in correctional settings around the world, R&R application remains unknown in Indonesia, especially in our correctional system. Next. In sport, in today's discussions, we want to talk more about R&R application in Indonesian correctional system, specifically in parole programs, in which based on role in the re-entry process of the offenders into society. Next, before we begin talk about parole programs and R&R, let me briefly describe and introduce you about Indonesian correctional system. So based on Indonesian Correctional Act of 1995, the goal of corrections in Indonesia is social reintegration that focuses living, live, and livelihood of the offenders. To achieve that goal, Indonesian government formulated three stages of correctional process that should be passed by each offender. The first is initial stage, which focus on admission and orientation of the offenders in the correctional facilities. And the second one is advanced stage, which focused on personality and vocational development for the offenders. And finally, the last one, final stage, will focus on the re-entry preparation for the offenders before they get back to society. For those who are eligible, the inmates have right to submit for a parole and serving their sentence outside prison. So parole in Indonesia is governed by the Ministry of Law and Human Rights under the Directorate General of Corrections or DGC and run by Probation and Parole Officer in Probation and Parole Office in local area. Parole lies upon the philosophy of Indonesian correction, namely pemasyarakatan, in which means social reintegration. So, the Probation and Parole Office will provide personality development and vocational training for the parolee when they serve their parolee outside of it. So, after this, Dannissa will explain about the R&R framework and their implementation in Indonesian parole programs. After you, Dannissa.
Okay, thank you, Fitra. Before we can go any further, I want to describe about the R&R framework, and I believe maybe some of you already familiar with this theoretical framework. R&R is one of theoretical framework to understand the reason why someone offend a crime and how to reduce the crime behavior in the future. This model offers a way to reduce the crime behavior without relying on the sanction. There are three main principles in this model: risk, need, and responsivity. The risk principle refers to personal and environment attributes that can be measured to predict future crime behavior. And there are two aspects in this principle. The first is predicting, to predict the future behavior, and matching, to match the level of risk of offender with the intervention. And second is need principle. There are two types of needs in this context: criminogenic needs that relate to the crime behavior and non-criminogenic needs that not relate to the crime behavior. In correctional process, we focus to change the criminogenic needs to reduce the crime behavior. And the third principle is responsivity. Responsivity refers to how interventions are designed and delivered to engage the offender. It would rely on the offender responsivity, and there are two types of responsivity. The first one is general responsivity, and second one is specific responsivity. The general responsivity doesn't need special design and delivery techniques in intervention. And for the offender who has specific responsivity, we need to have special design and techniques to deliver the intervention. And how Indonesia implement the R&R framework. According to our analysis, Indonesia correction is currently adapting the R&R framework in their initial process of parole. That is proved by the establishment of Indonesian risk assessment and criminogenic assessment that adapted from LSIR. In further, these instruments has been included as a part of image evaluation, which is presented in social inquiry report, and this report is one of consideration to grant the parole application. Even though Directorate General of Correction has been giving some effort to implement the R&R framework, they meet some challenges and obstacles. There are some principles that not fully implemented in parole programs, such as risk principle and responsivity principle. We found that there is no regulation that sets specific intervention based on parole risk level or responsivity. This problem may be caused by the absence of standardized intervention programs for parolees, and moreover, the field officer, who are the probation and parole officer, didn't receive any course or training program about the R&R implementation. Those things also made some variations in intervention deliveries that may not address the implementation of R&R framework and could lead to the failure in reducing the criminal behavior of the parolees. Besides those things, in There are only few research and literature about the R&R that fit in Indonesia context. Last, Indonesia has diverse cultures. There are about 500 languages and dialects in Indonesia, and that affect the characteristic of the parole, and it will require a lot of effort to implement the R&R, especially in the responsibility principle and risk principle. And to overcome that challenge and obstacle, we suggest in the future for the DCC to develop intervention program for parole terms to make sure that intervention delivery is in line with the R&R framework, and they should taken into account the level of risk before they grant the parole application, and the responsivity principle also should be considered in delivering intervention that targeting to the criminogenic needs. We also suggest to enhance the officer competency by giving course, training, scholarship, or conducting collaboration work with the research center. And that's the end of our presentation. And if you have any further inquiries, you can ask in the Q&A session or just reach us through this email or our ResearchGate account. Thank you.
Fitra, Dannissa, I really appreciate your panel and your presentation. And I'm a former probation officer, so I feel a kindred spirit there a bit too. So I don't have any questions from any of the attendees yet. So I would like to just give the attendees a moment or two to see if they do have any questions. And I'd just like to kind of, recognize the fact that, I'm here in the States and we have panelists here from Indonesia, Brazil, and India, and it's really quite amazing to be going through this and listening to everything. Now, Vipin says here, thank you to Fitra and Dannissa for highlighting the emergence of the R&R framework in Indonesia. I would wish to understand various initiatives focus on understanding the need aspect, the criminogenic need aspect of young offenders. How does the probation and parole officer work on those lines? And either of you can respond to that if you'd like.
Okay. Hi, Vipin. Thank you so much for the question. So, how it's about the criminogenic of the young offenders, and how does the probation or parole officers work on those lines. So let me give you further information that in Indonesia we have a different sections focusing on adult clients, correctional clients, and juvenile clients. So for juvenile juvie or juvenile clients, we have like it's much more complicated than treating the adult clients, because in juvenile clients we also give them in the when they are in the police yeah. So Dannissa, could you back me up please? Or
Okay, actually we have different methods to intervene the young offenders. We call it juveniles in here. And we already have criminogenic and risk assessment that designed especially for the young offenders. And the young offenders is aged under 18 years old. After they turn into 18, they should be moved into the adult correction process. That's it.
Okay, so thank you very much. I don't see any other questions that have popped up. So I just want to thank everybody for their participation here. We are all around the world right now, which makes this incredibly awesome. I would say that, I appreciated getting to have a little bit of interaction with all of you and learning a little bit from all of you as well. A little bit of housekeeping before I wrap up here. For anybody that wants to remain on this stream, whether you're presenting in the next panel or you want to watch the next panel, I'm actually going to be ending the panel. You'll have to come back in about 10, 15 minutes. That's just for, the way that we can kind of keep these siloed so we can put them up online. And also to give hosts a couple of minute break each hour. The videos from these panels should be up online by the end of the year. I think we're going to be posting them to YouTube if you'd like to see them or rewatch them. Emails will be going out about that today. I just want to say one last time how much I appreciated getting to interact with some of you folks. It's been completely enlightening, and I hope you've enjoyed CrimCon, and I appreciate your participation. And I hope that, if we do this again, which we intend to, that you'll come back as well. So with that, I'm going to say thank you and say goodbye.
Thank you.
Thank
Goodbye,
you.
everyone.
Bye-bye.
Bye.